Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients.
I think the Zoom will be for the second here.
I thought it was for Mr. Nadine's hearing, which is...
That's the second one.
Oh, I think he has to go first.
Oh, he did?
He did.
I think he's meeting with his client, Judge. I think his client's here, but I know he wanted to meet with his client briefly to go over the plea offer. I don't know.
Is Mr. Swiatek here?
I have not seen Mr. Swiatek. I have not seen him, Your Honor. I can go look. So I knew Mr. Medina was asking how long this process.
He's here, but he likes to hide out places.
Mr. Swiatek.
He's in the building.
Mr. Swiatek is in the building?
Yes, sir. 20 minutes ago he came.
Thank you.
At Hub City Soapery, visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
I don't see any reason why I couldn't, and I don't have any objection to the FDLE person being party to the argument. It's pertaining to their reports. I don't think it's a problem for them to be on the line, but if the court would prefer not to, I just think it might be more efficient, for instance, that they listen to each other, because they may have comments on each other. Basically, the motion is to exclude the FDLE report. It may be helpful for the FDLE person to hear Dr. Buffington, my expert, defense expert, and vice versa.
So is your expert going to be here too?
Yes, by Zoom, Your Honor.
Okay. Would you all come forward?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446. C&C Asian Market, located at 294 North Main Street in historic downtown Crestview, has the largest selection of Asian noodles, rice, and sauces in Northwest Florida. With more than 2,000 items on their shelves, you'll have no problem finding exactly what you need for preparing that authentic Asian meal. Open Monday through Thursday from 9 till 8, Friday and Saturday from 9 till 9, and Sunday from noon till 6 p.m. Be sure to...
We just had somebody coming into the room. We're trying to get our Zoom set up in the courtroom. Did I stop the talking soon? Yeah. Good. Okay. So we are we're here on a Zoom hearing, and we're here on case number 2018 CF 1569 and 2018 CF 2196. And we're here specifically on a motion in limine filed by the defense. Now, there are...
Your Honor, sorry, there was one other case that we're here on.
Okay?
22 CF 246.
Correct.
That's the new law.
That's the new law, George. Very good. So we have 3 individuals, but one's on video. Who has got their video turned off and their sound?
I think Dr. Buffington is muted.
Well, I understand they're muted, but there's an there's another person on my screen.
Yes, that would be Dr. Allendaver from my office. I'm traveling today, so I have my staff available in case I need to produce anything for you.
Okay. I'm not calling the witnesses. I'm not clear about why they would be.
I think that basically Dr. Buffington works very closely with his staff, so he wanted his staff to be able to listen in case he's out of town, in case they needed to get a document or something. We're ready to proceed. If there's any objection, we can just proceed with Dr. Buffington on the screen. But I didn't see
Well, if you're going to be, I want to be on video. We can be muted, but we're going to be on video. We need to know who's present.
We can identify the individual, Your Honor.
Okay.
Yes,
well,
I will turn my camera on your own.
Okay. Okay.
And this is, okay, and then I think the FDLE person is on the phone, Zoom as well. Is that correct?
Yes. So we've got Dr. Buffington and ma'am, life height, how do you pronounce that? What is your name, please?
Nicole Lightman.
Okay, is that the state's witness?
Yes, that's the state's witness.
Okay, and then we've got, and I'm going to certainly mess this name up, Al McGovern.
Yes.
Doctor. So, and you're in Dr. Buffington's office. So, the way we should consider this is, you all, I don't know if you can see it here. You need to put on that screen, go ahead and put it on gallery.
Okay, you'd rather on gallery than
speaker? Yeah, put it on gallery rather than, so they can see everybody. So, if you, what's that?
That's just what we see. They can have their screens however they want.
Yeah, but I want to be able to see. So, the court, as you can see, there's some people out in the gallery in the courtroom. And until you're called as a witness, you all are out in the court, are out in the gallery. Okay, you're participating in an open hearing. There's no objection. There's been a no objection filed. I know you all are both appearing as experts today, but you're sitting out in the gallery. You're welcome to sit out in the gallery. The only thing I would ask is that when you're not testifying, that you mute your screen. I'll try and do the same. So there's no feedback and whatnot.
Your Honor, in reference to Dr. Buffington's staff being on Zoom, can Mr. Medina make a representation whether or not anyone else but Dr. Buffington is going to be testifying?
No, only Dr. Buffington is testifying. His staff, this colleague has worked with him on this report, and she's familiar with the documents, and she's not going to be testifying.
So, Your Honor, the state would invoke the rule. I do believe that if there are experts testifying, they may stay in the room while other people are testifying. However, as long as the other people that work with Dr. Buffington are not testifying, I think it's fine for them to just observe.
That's all she's doing is observing, Your Honor.
Okay, so the rule of sequestration has been invoked. So that means that if there's anybody else in the courtroom that is going to be a witness here today, needs to step outside. Is anybody, do either of you plan on calling anybody that's in the courtroom?
No, Your Honor. The only witnesses are the FDLE representative and Dr. Buffington.
Okay, very good. So, with that, this is your motion.
Yes, Your Honor.
Mr. Medina, and I have reviewed your motion and the state's response. And
Your Honor, before I get to the four squares of the motion, I did need to put something on the record, and the state may want to put something on this issue as well. But basically, there's a fourth case that Ms. Bradshaw is party to, 23 CF 1870. That's not part of this motion, but I did want to reference it because the state has made a global offer to Ms. Bradshaw it's indicated that if we go forward with this motion in limine that it's going to withdraw that offer, and it is an 18-month community control reinstate and modify offer, and I did want it on the record. Two things. Number one is that Ms. Bradshaw is, against my recommendation, is rejecting that offer, and that's because of number two is that the state is basically indicating that it would intend to go forward with felonies charges in 22 CF 246 and 23 CF 1870. There's also the prospect and likelihood of a VOP evidentiary hearing in the 18 CF 1569 and 18 CF 2196 with a lower burden of proof on the state. Of basically any violation can trigger that, and my understanding is that even with the new law charges reduced to have only misdemeanors, the state's position is that Ms. Bradshaw would score prison, and so it's against my recommendation she's turning it down. I know that she believes it's in her best interest to do that, and I respect that, and I'm going to obviously do my best for her. Does the state had indicated to me that it intended to withdraw the offer. Is that correct?
That's correct, Your Honor. So on the two new law charges, the state agreed to allow Ms. Bradshaw.
The numbers for the record?
22, the 22 CF 246 case that we're here for a motion on today, and she also has a new charge in 23 CF 1870. The state was going to allow her to plead to misdemeanors in both of those cases, and then the state was going to allow her to do the probation and parole's recommendation of community control with mental health and substance abuse treatment. And since she is going forward with this hearing today, the state is going to revoke that offer, and the state will be.
And what is the with the revoking of the offer? What would the maximum exposure be for the defendant?
Your Honor, on the 22 CF 246, there is a misdemeanor DUI that carries a maximum of a year.
I think it's 6 months first DUI.
I'm sorry, thank you, Mr. The maximum incarceration is a year. The maximum probation is 6 months. The maximum probation is 1 year.
Right.
The threat against the law enforcement, that is a misdemeanor. That is a maximum of 1 year. And the resisting an officer without violence, with violence, that is a 5-year maximum, Your Honor. The 23 CF 1870, that is a battery on a person 65 years or older, Your Honor. Give me just a second.
And there were 2 battery upon a person 65 years old or third-degree felonies with 5 years times 2 for those 2, and then there was a grand theft charge of third-degree felony 5 years. In addition, in the VOP cases in 18 CF 1569, there was a felony VOP with a 5-year statutory maximum on the underlying charge. In 18 CF 2196, there were apparently 2 felony VOPs on second-degree felonies, which each holds a 15-year max. So I don't want to mess up on my math, Your Honor, but the 2 VOP cases looks like 35 years. The 4 new law felonies are 20 years, so that, without getting into misdemeanors, that looks like 55 years, the potential maximum. And of course, I'm not saying likelihood, but the court asked about maximum.
there's a maximum exposure of over 50 years in state prison, and the offer on the table is 18 months community control. No incarcerative sentence.
That's correct, Your Honor.
And the defense is turning that down.
The defendant is focused on the DUI charge that's the subject of the motion in limine, because her parents who are in the courtroom are, especially her mother who's disabled, is dependent on her driver's license, so she's concerned about the driver's license suspension. She's talked to DMV and is concerned that even if the court enters an order supporting business purposes only, that it is the DMV's prerogative. That, nonetheless, I can't make her value judgment for her, but it's against my recommendation if she's declining the state's offer.
I'm certainly not going to get in the middle of any negotiation, but I would urge the defendant to be more concerned about her incarcerative sentence or lack thereof rather than a driver's license. But that's all I'm going to say. Counsel, you may proceed.
Your Honor, she's decided she would like to talk to her parents, and so if we can we'll recess our case and allow Mr. Switek's case to go forward. I think that's probably better. And I know that Dr. Buffington has a responsibility in an hour and a half in another location, so hopefully the matter before us won't impede his testifying, Your Honor. But I don't want to
Can't make a promise on that one. So what I'm going to do on this, I'm going to go ahead and put everybody in the waiting room who is on this Zoom call, and I'm just going to leave it up. So you'll be able to see what's going on in the courtroom, but I'm going to put it on mute on my end and put everybody in the waiting room. So then when we do, we'll come back and I'll kind of call out, figure out where everyone's at. And I appreciate everybody's patience and your participation in this process. Thank you. Thank you. Okay, so we're here on the sentencing of Donald Dwayne Holder. Mr. Switek, you want your client to sit next to you, I assume?
Yes, indeed.
I have some materials to share with everyone.
Okay.
I did send court emails earlier today in response to the state's sentencing memorandum. But I didn't include these two cases.
I've got those printed off. I think I have those cases. They've been filed.
This is the first time I'm seeing this one, Judge, so I don't think it was attached to the...
What's the case number?
Glenn?
There's a state v. Platt.
That's cited.
And
okay, whatever you got.
State versus Diaz, which is
okay.
A follow-up case.
Okay, thank you.
I think I made it.
Don't give me the one with your notes. Okay, thank you. the state wish to make any opening remarks?
Your Honor, I believe generally we let the defense
Let
go
the
first.
defense, would you like to make an opening remark?
Yes, Your Honor. Your Honor, we're here today on State of Florida versus Donald Dwayne Holder. It's case number 2022 CF 1875. Glenn Swiatek for Mr. Holder. The first thing I'd like to address, which I think would be the proper way to do it, is to address our motion to strike.
I have the motion to strike.
Your Honor, the first issue presented in the motion to strike is the state's reference to uncharged conduct. In particular, paragraph 2, where the state says that Mr. Holder requested that Charles send photos of his daughter, requesting some revealing ones, whereupon Charles sent images of what appeared to be a 14-year-old, a young girl. The defendant sent a picture of what he stated was his 14-year-old daughter and told Charles that he had just played around with her and they were active as a father and daughter. The defendant ultimately offered to come from Alabama but did not travel. We take issue with the uncharged conduct of implying that the defendant had somehow been sexually involved with his daughter. That's not charged here. In fact, it's not even relevant to these proceedings because if it indeed did happen, that would have happened in Moss Point, Mississippi, and not in Okaloosa County, Florida, or any county in Florida. Then in the next paragraph, paragraph 3, he also admitted to setting up a mega personal account where he received links to view other images and videos of young girls. He did admit that these actions were wrong. Again, that's not why we're here today. Not before the court. It's uncharged conduct. Then on page 2, he also told Charlie that he had been engaging in this type of behavior and sharing his own.
Where are you at?
I'm sorry. 1, 2, 3, 4, 5, 6. Excuse me. The third paragraph from the bottom, where it begins. This is not a minimum guideline sentence, a guideline case.
Okay.
And then further into that paragraph, he also told Charlie that he had been engaging in this type of behavior and sharing his own daughter for a while. There is no question that this defendant is interested in having sex with children, and that makes him a danger. The only way to assure he can act on his desires is to incarcerate him. That, again, is uncharged conduct, not related to the facts of this case. And then I'd like to come back to that paragraph in a moment. In fact, I can just go to it right now. What could be fundamental error here, according to the case law, is that the state is now referring to speculative future offenses. There is no question that this defendant is interested in having sex with children, and that makes him a danger. The only way to assure that he cannot act on his desires is to incarcerate him. That's a speculative future offense. Then on the last page, a period of incarceration of this length will assure that Mr. Holder does not have the opportunity to victimize an actual child and assure the safety of the community while he receives the statutorily mandated.
Where are you reading?
On the next page, the last page of the written memo.
Okay. Start over again on that.
A period of incarceration of this length will assure that Mr. Holder does not have the opportunity to victimize an actual child and assures the safety of the community while he receives the statutorily mandated sex offender treatment in a closely controlled environment. Again, speculative future offenses. This is addressed by Goldstein versus State. Does the court have a copy of that case?
I do.
At pages 7 and 8,
okay.
This addresses the prohibited future offenses reference. Additionally, in both Barnhill and the Instant case, the judge apparently feared that the defendants would commit new criminal acts of abuse that they were never accused of committing, and took this speculation into account when imposing sentence. As in Barnhill, this fear was not based on the evidence before the trial court as to this defendant. In a different context, this court has stated, a sentencing court may not rely on unsubstantiated allegations of misconduct or speculation that the defendant probably committed other crimes when it imposes sentence. Citations. Based on mere allegation, next page, based on mere allegation or surmise violates the fundamental constitutional rights of the defendant. And here's the important part. It seems even more evident to us that a court cannot rely on crimes it fears the defendant might possibly commit in the future simply because he has committed the charged offenses. In the case as to uncharged conduct, I've attached to the motion of strike Wyrick versus State. It's a brand new case, September 1st, 2023. 2023 Florida App, Lexus 6113, second DCA.
This is the State v. Platt?
No, Wyrick. Wyrick versus State.
Wyrick, gotcha.
In particular, headnotes 2 and footnote 3. Headnote 2 begins at the third from the last page.
Okay.
Right in the middle of that paragraph, it says, consideration of an improper factor, such as uncharged offenses, goes to the heart of the sentencing process, and thus the error is fundamental. Dropping down to footnote 3, which is on the last page, the sentencing judge in this case also agreed to hear the evidence of the uncharged conduct and was engaged when that evidence was being offered and argued. Our opinion does not rest upon these additional facts, but we mention them to caution trial courts from commenting on impermissible sentencing factors, such as uncharged conduct, if they should be presented. even without objection, which was the case in Wiley. So, with those facts presented and the case law provided, we would move to strike the motion, the state sentencing memorandum.
Your Honor, the state does believe that its sentencing memorandum is entirely appropriate. As far as addressing the uncharged misconduct, Your Honor, the conduct that the state refers to is contained within the chats that are also provided. Those are the evidence in the case. If the state, some of that is the state's interpretation as to whether or not those chats show an interest in children, but the words therein, the fact that his daughter was involved, he was just playing around with his daughter, that is actually contained in the chats. That's not uncharged misconduct per se. That's going to show the interest in the children. It's going to go to the totality of the circumstances of the sentence that should be imposed. Additionally, Your Honor, when we refer to, for instance, going into chat rooms on multiple occasions, when we refer to him viewing images of young children, to setting up the mega personal account, that's actually all contained in his own statement to Jackson County Police. So again, that's not uncharged misconduct. That's the totality of the evidence in this case. We're not saying that he specifically did that, but he's admitted to it. So frankly, it is appropriate for the court to consider those things. And also, as far as the statements that he made during the confession that now Mr. Switek is trying to say the court cannot consider, those are actually some of the basis of his argument for a mitigation for a downward departure, the fact that he confessed and cooperated. So we don't believe that he can have it both ways. He can't ask the court to consider it, but then now use it as a basis for a motion to strike. But those are his own statements, so we believe that is part of the totality of the evidence in the case, and certainly appropriate for the court to consider it as part of the sentencing, as fact as it's his words expressing his interest, his desires, what he was actually doing. That's not uncharged conduct. That's what he's saying he did. That goes to his interest in children. It goes to his intent to have sex with his 10-year-old. And that's what we're here for. Additionally, Your Honor, as far as the speculative, the state has asked the court to hold Mr. Holder accountable, and the way we ask to do that is incarceration because, Your Honor, we feel based on the nature of the charges and the clear interest that he expressed in coming to have sex with a 10-year-old, the best way to assure that the public is safe and that no actual child is endangered is to, in fact, incarcerate him while he receives the appropriate sex offender counseling and then is designated for the rest of his life. So we do not believe that that is an improper argument as well, Your Honor. And basically, my key point is, this is the state's argument. This is the state's take on the evidence, but it is based on the evidence that is before the court. So we don't believe it's improper, and we'd ask the court to deny the motion to strike.
Your Honor, as to the speculative future offenses, what Ms. Bossow has offered to the court may indeed be some type of proper argument. Unfortunately, it doesn't marry up to what is written in her memorandum. You know, in the memorandum, Ms. Bossow states that we're concerned about future issues coming up, future sex offenses against minors. And it's all in the future. It's speculative, and it's uncharged. And it's not properly before this court. As to the uncharged conduct itself, not only is it fundamental error, you then presented, not today, but some court in the future, should Mr. Holder indeed be charged by the state of Mississippi, there's a double jeopardy problem. Because if the court considers that in its sentencing, he's been sentenced for actions that took place outside, if they did, outside of the jurisdiction of this court in the state of Mississippi, in Jackson County, I believe.
Thank you. So the court finds that court agrees with the state that this is not uncharged conduct, that it is central to the sum total of the charges in this case. And as it relates to the issue of speculative and future, it's a little bit tricky because in one of the cases, the very next sentence, which nobody's going to disagree with here, is that it says, while protection of the public is clearly a proper consideration, protection of the public is clearly a future endeavor. It's not in the present, it's not in the past. And so there is some consideration of protection for the public. And for those reasons, I think that it is not proper to strike. The court denies the motion to strike. Counsel, you may proceed with your argument.
All right. As to the motion for downward departure, Your Honor, I'd like to save that for a closing argument.
Okay. You wish to make an opening remark on the as to the sentencing? You don't have to, but if you wish to.
Well, I could tell the court that there is no agreement with the state. I thought we were going to get there and not have the necessity for a hearing today, thus the tardiness of my memorandum. But the state is correct in its memo that we have one charge. It carries a 5-year maximum. There is no cap. It carries 56 sentencing points, which equates to
Let me understand that. On the plea and sentencing agreement that we're operating, the plea to the bench on this, I didn't notice that it was one charge, but I see two charges here.
Count 2, I believe it was count 2, was null promised.
Yeah, but there's a count 3. I'm just looking at there's 2 counts on the plea and sentencing agreement. And they both have 5-year maximums. I'm just wondering, maybe I misunderstood. Your
Honor, there was the state's information, that was just for clarity, so the record's clear, that was filed on August 9th, 2022, did charge solicitation or using a computer to facilitate or solicit a parent or legal guardian or custodian for consent as count 1, and then count 2 is unlawful use, and that's what we null prosecuted.
Okay. So, if y'all will come forward, I'm going to show you. I'm still confused.
Check out our Facebook page for our weekly specials.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and
The state would be null prosecuting count 2 or
Very good. And this was originally a plea to the bench, so that's
Correct.
what we're dealing with. So go ahead. I'm sorry, I didn't mean to interrupt you, Mr. Switer.
I think I left off with the sentencing points being 56 points for a level 7 offense. And the math makes it a low-end guideline of 21 months. will be arguing for below that at the end of the sentencing hearing.
Very good. Does the state wish to make any opening remarks, or do you wish to reserve?
We'll reserve the closing, Your Honor. Thank you.
Okay. Mr. Switek, you may proceed if you have any witnesses or wish to provide any evidence.
I'm going to call Donald Holder.
Very good. Come up to the witness stand. Mr. Holder, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Counsel, you may inquire. And you may sit or you may stand at the podium. It's up to whatever you wish.
Okay, thank you, Judge. I may go back and forth.
Okay.
Okay, would you please state your name for the record, please?
Donald Dwayne Holder.
And Mr. Holder, where do you live?
Currently in Grand Bay, Alabama.
Okay. And at one time, did you live in Moss Point, Mississippi?
Up until I got incorporated last year, and then whenever I was released, I moved to Grand Bay.
Okay.
Sir, would you pull that mic to you just a little bit?
Yes, sir.
Thank you.
When you say incarcerated, you mean that at the point in time where you surrendered and were arrested and you went to first appearance and then you subsequently bonded out, correct?
Yes, sir.
All right. Now, have you reviewed the state sentencing memorandum?
Yes, sir.
And the text messages and the images?
Yes, sir.
Okay. The state implies that you sent an image of your daughter to an undercover sheriff's investigator. Is that correct?
No, sir.
Okay. Who is that image of?
It was an image off the internet.
All right, so it's not your daughter?
No, it's not.
Do you have any idea who it is?
No, I do not.
The state also has alleged that there was a plan to meet this supposed 10-year-old victim in this case. Was there a plan to meet?
No, sir. Never once did we discuss meeting, no.
Well, it was kind of bantered about, though, that you would like to, correct?
I don't think so. Yes? Yeah.
Okay. Was there an agreement between yourself and this undercover officer to meet at a specific place?
No, sir.
Or a specific time?
No, sir.
Or a specific date?
No, sir.
Did you take any actions to meet the alleged father of the alleged victim in Okaloosa County or any place in the world for that matter?
No, I did not.
The activities that were alleged are, is it correct that they were limited to chat conversations?
Correct.
And you took no action in furtherance thereof?
At no time. I did not.
There's going to be some testimony in a moment about a rehabilitation plan at the Mercy House. Are you familiar with that?
Yes, I am.
And would you be willing to enter into the program at the Mercy House?
Yes, I would.
What do you understand the Mercy House to be?
It's a rehabilitation for different types of offenders, drug, sex, and it's a 1.5 to 2 year program that helps you with I'm trying to think of the right words to use. It's a Christian-based program that helps you build your relationship with the Lord and keeps you focused on the right track.
Okay. Now, in that regard, since your arrest, have you been focused on the right track?
Yes, I have.
Have you been on the internet at all?
No, I have not.
How have you gotten emails from me?
My wife takes care of that.
Okay. So she prints them out and gives them to you?
Yes, sir.
What else have you done?
I go to church every Sunday and Wednesday if I'm not working. I help with the church, the men's group. And I work. If I'm not working, I'm at my parents' house. If I'm not at my parents' house, I'm with my wife.
And what is the name of the church?
Three Rivers Assembly of God.
How long have you been attending?
I've been going there a little over a year.
And how long have you been involved with the men's group?
Since I started going back there last September, no, August. Whenever I started going back to that church, yes, sir.
Okay. What do you think of the actions that you're accused of?
I'm ashamed of the actions that I'm accused of.
And you're fully committed to enter into a rehabilitation program to avoid getting caught up in that situation again?
Fully committed, sir.
Mr. Holder, those are my questions for you. The state may have some.
I don't have anything, Mr. Holder. Thank you very much.
Thank you, ma'am.
Thank you, sir. Let me step down. Mr. Switek?
Your Honor, I would call Pastor Gene M. Swider. Did I pronounce that right? Is that correct?
Sir, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Thank you. Counsel, you may inquire.
Sir, could you state your name, please?
Gene M. Swiler.
And what do you do for a living, Mr. M. Swider?
I pastor
Sorry.
I pastor Three Rivers Assembly of God Church.
And how long have you been doing that?
At that particular church, it'd be 24 years in May.
Okay, and you say that particular church, were there other churches
Yes.
prior to that?
Yes, sir. I've pastored 45 years in total.
And do you know my client, Donald Holter?
Yes, I do.
And how do you know him?
I've known him since the early 90s, friends with family, and he's been attending our church for about a year and a half, I guess.
Okay. And you're familiar with the allegations against Mr. Holder?
Yes, I am.
And what do you think of those?
What do I think about the
charges?
The charges?
Yeah.
I think it's, I want to get the right word. He put it, it's shameful, it's degrading. And it's proven it's the way to be.
Yet you still welcome Mr. Holder into your church.
Oh, yeah. Jesus said, whosoever will.
I'm sorry, sir?
Jesus said, whosoever will.
Are you familiar with a program run by the Mercy House?
Yes, sir.
And how are you familiar with that?
I was part of the original board to set that ministry up and have been associated with it for 23, 24 years.
Okay, and where is it?
It's in Hurley, Mississippi.
Okay. And as I recall, Hurley, Mississippi is just a little bit north of Pascagoula and Ingalls, correct?
Correct.
And who is it run by?
Reverend Danny Pierce.
How could it be of help to Mr. Holder? Or do you know how it could be of help to Mr. Holder?
Yes, sir. I have watched hundreds of men in the 23, 24 years that I've been associated with that ministry come through Mercy House. And to be very truthful, all of them it doesn't take. But way over a majority, probably 65, 70, maybe even 75% of the men come out free from their addictions, free from their life controlling problems.
And what kind of addictions does the Mercy House address?
Brother Pierce has had, or Reverend Pierce has had anyway from drug addictions, pornography, alcohol, and some men have been court ordered there for sex offenses.
Do you have any doubt that this program could be of help to Mr. Holder?
No doubt whatsoever. I believe in it totally.
Okay. Pastor, those are my questions for you.
I don't have anything to add.
Thank you.
Mr. Schweikig, do you wish to call next?
Yes, Your Honor. I would call Danny Pierce. Can you negotiate up there, or would it be easier to stand for you?
Take your time. Sir, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Would you please state your name for the record?
Danny Pierce.
And Mr. Pierce, where are you employed at?
Mercy House Ministries.
And what do you do there?
I am the executive director.
How long have you been in that position?
25 years.
And what specifically do you do in that ministry?
Everything consists of ministering to men, teaching class, work detail, the whole of the program from daylight to dark most of the time, and helping men, change their lifestyle, basically.
And do you have any help doing that?
I do.
Okay. And how many people are helping out?
Probably tax titling out the door, about 9 staff.
Okay. And how many people would be enrolled at Mercy House at any one time?
Say that again?
How many people would be attending?
We have right at 22 students right now.
Okay. And is that typical?
Not necessarily. Before the COVID virus, we had anywhere from 30 to 35. Our numbers dropped. After the virus, we average 18 to 25.
Okay. What does a typical day consist of for somebody that's in that program?
We wake up at 6:30, personal hygiene, class at 7. From 7 to 7:30 we do personal devotion. 7:30 to 8:30 we eat breakfast. After breakfast and everybody gets cleaned up, then we go to class for 4 hours. If the guys have been there longer than 4 or 5 months, we have what we call work detail. We do odd jobs in our town. People hire us to finance what we do. If, not, the newer students are in class from 8:30 till noon every day. And in the afternoon, we eat again, clean up, and after that, then all students work after that. We don't lay down in the bed at all. We do class and then work. And in the evening times, we have study hall, supper, and then 10 o'clock. 9:30, they go to their rooms. 10 o'clock, we go to bed.
Okay. Was Pastor Emswire correct that you have taken in court-ordered people into your program?
Yes, sir. I have some there now.
And how often does that occur?
Probably half of our students are court-ordered. We have quite a few that come voluntarily, knowing full well they're going down the wrong road. But I wouldn't be scared to say half of our students are court-ordered. I get them from all over the United States.
Oh, really? And is this a residential program?
Yes, sir.
Is it a lockdown facility?
Not necessarily locked down, but in-house all the time. They can't go. We have passes now, but they have to be in the program for about 8 months to get an off-field, what we call an off-field pass. They do get visits once a month. If they earn that, they have to earn that. So lockdown, maybe. It's according to what your definition of lockdown. They have to stay there and they can't go nowhere. If they go anywhere, they're on my bus.
Okay, but there's no steel door with a lock on it that keeps them in.
That's right. And if they choose to come and leave, just because they're court-ordered a lot of times, I don't like this statement, but some of them would rather go to jail than do right, and so we call the authorities immediately, and a lot of times our Jackson County is where we are. I got several of the officers that are dear friends of mine, and so they will escort them to jail so they can extradite them to wherever they go, or the judge issues a warrant for their arrest upon their departure if they choose to leave. We don't have that many, but there are a few. There's some of them that court-ordered that don't stay.
Okay, what about a court-ordered person that doesn't necessarily leave but doesn't participate according to the program's expectations? What do you do?
Say that again?
So what about a person that doesn't necessarily leave the program but stays but just does not participate to the level that you require?
I don't really have a lot that don't participate to the level that we require unless they leave. So to answer that would be, I can dismiss them too, I guess would be another way, and then we call if they don't operate to our standard, and I know that we're going to have to dismiss them, I call the authorities before they even know I'm going to dismiss them to find out what they want me to do with them. So I have had that happen. Okay. Not many, but it does sometimes.
All right. And Mr. Pierce, I may have been negligent. Are you also a pastor?
Yes, sir.
Okay. And you're associated with the Three Rivers Assembly of God, is that correct?
Yes, sir.
Okay. Well, Pastor Rivers, Pastor Pierce, those are my questions for you. Thank you.
Your Honor, I don't have any questions. Pastor Pierce, thank you, sir.
Thank you, sir. You may step down. Mr. Switek.
Charla Holder.
Ma'am, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Counsel?
Thank you, Your Honor. Ms. Holder, would you please state your full name, please, and spell it?
Charla, Sharla, Holder, Holder.
Okay. And you're here to testify on behalf of my client, Donald Holder, correct?
Yes, sir.
And how do you know Mr. Holder?
We're cousins.
And how long have you been cousins?
55 years.
Okay. And you're familiar with the allegations against my client?
Yes, sir.
And what do you think of them?
I think that that Donnie made, some mistakes, and he made that mistake while under the influence of alcohol, and I think he is remorse. I think that that he's a changed man. That's all of that transpired.
You say he was under the influence of alcohol. Do you know him to have an alcohol-related problem?
I know that in the past, yes, sir, that he drank.
And when you say he drank alcoholic beverages?
Yes, sir. I'm sorry. Yes, sir.
To excess?
Yes, sir.
Did he have any other addictions?
He had an issue with gambling.
Okay, and he's there on the coast with all the casinos, correct?
Yes, sir.
And as far as the alcohol and the gambling, have you seen him participate with any gambling venues or buddies or anything like that, Friday night poker game? Or?
No, sir.
Okay. When did all that, or did it come to an end?
Whenever, after he got out of jail, after he was arrested for this.
And how often do you see Donald?
All the time, for sure, every Sunday, and then we talk throughout the week, and we've always had a close relationship, and so as soon as, well, actually, he was still in jail after he was arrested, and he contacted me. Well, his parents contacted me, and then I learned how to contact him while he was in there.
Have you seen him access the internet since he's been out?
No, sir.
What would be your recommendation to Judge Ketchell today as to how this case should be handled?
I think that that Donnie is very ashamed of what he did. I think that he is a changed man. He has totally given himself over to the Lord, and I know that going through the program at Mercy House will definitely benefit him, and I just think it would be better beneficial than being put in prison as far as the type of program that they have there at Mercy House.
Okay. Are you concerned about, are you telling us you're concerned about rehabilitation then?
In prison?
Right.
Yes, sir.
And
or the lack of.
Yeah. And how familiar are you with the Mercy House?
Very. I'm from Hurley, and just over the years I've known about it, and over the past few years I've gotten to know Danny, but I've known how that works, and actually have contributed to that donation wise, because it's just a successful program.
All Ms. Holder, those are the questions I have for you.
Your Honor, I have no questions, Ms. Holder. Thank you, ma'am.
Thank you. Teresa Emswire.
Ma'am, would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do, and I have a mouthful of Red Hots, I'm sorry. I was very thirsty, so I took candy. I'm trying to get rid of it.
Mr.
Swiatek? Yes, Your Honor. Ms. Emswire, would you please state and spell your name?
Teresa Emsweiler, Teresa. My last name is spelled Emswiler.
That's fine. And are you married to Pastor Gene?
I am.
How familiar are you with Mr. Donald Holder's problems that he's in court for today?
I'm familiar. I talked to him probably almost at least 2 or 3 times a week since all this happened. My husband and I have met with him several times, and then his parents and my parents are best friends, and so we just had a relationship for a long time, a friendship.
You know, everybody's friends and everybody's relatives will always come to court and testify on their behalf. Why should this case be looked at any differently? You're familiar with the allegations against him, right?
I am.
How could you testify for somebody given the nature of what he's accused of?
Well, I don't feel like I'm testifying for somebody. I feel like I'm testifying for a man that I knew previous and I know now. And I've watched him change. I believe that people do change. I know that the allegations are horrendous. I have granddaughters. In fact, I have a 10-year-old granddaughter. I will tell you that he's very, very cautious. This is one question that we didn't ask and you haven't mentioned, but even at church, he gets out of there as soon as church is over so that he is not around children. He won't go to the back without his wife or Charla. If we're going to eat, we have to pass the children's church area. And he is very, very conscientious about children and not being, following the court's mandate. From what I understand, I've not read the mandate, but from what I understand, he is not to be around children. And I can truthfully say, right after he got home, his mom and dad had a big 4th of July thing. I believe it was 4th of July. It was a holiday. And he wouldn't even go because there were his little cousins, and his cousins had their children there. So he's been very, very conscientious about following the rule of law. And honestly, I've never known him to not follow the rule of law until now. I don't know of any trouble. I know he's in trouble now, and I'm not trying to say that that's okay, this is okay, because it's not. But I do think that people can be rehabilitated, and I'm not sure that prison is the answer for that. I don't know that we see the success rate with former people that spend their 5 years or 10 years, whatever they do. Unfortunately, I think we all know they come out and do the same thing again. And I would just love to see him continue on the path that he's on now, instead of being put in a place where he might not have the opportunity to build the whole man. Because I think that's what we should be about, is building the whole man and not just, punishing him for something that possibly, or he made the mistake, we know that. But I just feel like that he is very capable of continuing on the path that he's on now.
What do you think about this program at Mercy House?
Well, I think because Danny, I know Danny, and I know his past. In fact, he was a raging alcoholic from a very young age, and I watched him nearly destroy his family. He did destroy a family, as a matter of fact. His drinking problems, and when he got on the right path, he went through a program himself, probably 30 years ago, and God gave him the opportunity to open this program, and every day I see him trying to get men back on that right path and making, citizens that we're proud of, families are proud of. So I know what Mercy House does. I have served, in fact, I guess I serve on the board now. I haven't been to a board meeting in a minute, but I serve on that board, and I know what they do. I know that they try to instill values in the men that they work with. And we actually have many men and ladies who have gone through similar programs who are in our church. We have a group of people. So I know it works if you work it, just like anything else.
It sounds like, with what Pastor Pierce has said, that it's a disciplined and structured environment.
Very disciplined. When you're asking him some of the questions, I thought, you know what you do? You give them a discipline if they don't. They have to do things that, different types of disciplines that they may require. Not anything detrimental to them, but they might have to read a book and write a book report on it, something that betters themselves. And it is a very structured program, and sometimes that's what we need to get back on track.
Well, that leads right into where I was going to go. You believe that he needs the discipline and structure to get over this problem that he has, and the alcohol and the gambling as well?
I think that because of the structure, we all need structure. So I think for him to be in a structured environment for 12 to 14 months and get stronger, because I think that's what happens is we build upon where he's already at and just begin to build on top of that. And that's what Mercy House, I believe, does. It gives them a daily structure that helps them to understand what is it really important in life.
Well, the Department of Corrections in their prisons, they give you discipline and structure as well. Why would Mercy House be superior to a prison facility that's going to get them up at 5 a.m. and,
Well, in my personal opinion, and not just my opinion, but in my personal experience, I've not seen many prison systems, or many prisoners, I should say, because they can watch TV or play cards, or after they get up in the mornings and go eat breakfast. They might get them up, but if they decide they want to lay down somewhere, they can. I just think the structure is way different than what the structure is. I think the structure for a program like Mercy House is rehabilitative in every way. Whereas in prison, I think you can pick and choose what you want to do and what you don't want to do, and you can't do that at Mercy House. Everybody does the same thing.
And eventually he's going to get out of prison and then...
And is he going to be a menace to society again? Who knows?
All right. Well, those are my questions for you, ma'am.
No questions. Thank you.
Thank you.
Thank you.
And finally, Judge, I would call Alicia Holder.
you please raise your right hand, ma'am? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Counsel.
Thank you, Judge. Ma'am, would you please state your name for the record and spell it?
Alicia Holder, Alisha, Holder, Holder.
And are you related to my client, Donald Holder?
I am. I'm his wife.
And how long have you been his wife?
I've been his wife since March.
Of 2023?
Yes, sir.
Well, Mr. Holder was arrested in 2022, as I recall.
Yes, sir.
But why would you get married?
Because I love him and I've seen a change in his life the day that he told me what had happened. I wasn't there that night that it happened, but I saw a change in him. I've known him for 53 years.
And what do you know about the allegations against him?
I don't know every detail. I don't think that's for me to know. I think that's for between him and God. But I know enough to know that I would support him through this, and that's why I married him.
What's going to happen if, let's say, the worst case scenario and Donald gets 5 years in prison today? What's going to happen to the two of you?
I'll be there when he gets out.
No doubt.
No doubt.
What do you know about the Mercy House program?
I know a good bit about it, and something that, as all of them were testifying, that I really relevates in me is most of those guys, they learn the Bible. That's a conversation that me and Donald has all the time. He questions, he wants to know more about the Bible. Most of them have a scripture that they stand on in their life. And I've seen success through that program. It gets people out of the deep dark that they're in.
You know, in my line of work, I get to deal with a lot of people that go to jail and that go to prison. It seems like a lot of them find Jesus while they're in the jail and in the prison, or in the prison. But they leave him there when they're released. You think that's going to happen in this case?
I don't. He found him before he went for a month. He was with him when he was there for a month, and he's been there ever since. He got out in August of last year.
Well, since he's been out, has he been complying with all the court's orders?
Absolutely.
No internet?
Sir?
No internet?
No, sir.
Staying away from schools?
He doesn't go to schools.
Staying away from children?
He does. He will not, like Sister Teresa said, he does not go near a child.
And if he goes to church, he's supervised?
Yes, sir.
What's your recommendation today to Judge Ketchel?
I believe that Mercy House is where he needs to be. I have a brother that has been in prison. It did nothing for him. It didn't rehabilitate him. He came out and did probably worse than he did for the reason that he went in. So I don't think that a 5-year sentence is going to do what he needs. It's going to be the program that he goes into that gives him a foundation in Christ, and not a structured facility as a prison is.
Okay, those are my questions for you.
Questions, Ms. Holder? Thank you.
Thank you. You may step down. Mr. Switek.
Your Honor, if I can break protocol and recall Mr. Holder.
Okay. You're still under oath, Mr. Holder.
Yes, sir.
All right, Mr. Holder, at some point back in 2022, sheriff's deputies showed up at your door, correct?
Correct.
And do you know why they came to your residence?
I didn't at the time, but I found out, yes, sir.
And what did you find out?
That they was serving a search warrant.
And what were they searching for?
My phone, internet, search for child, I guess you say child porn.
But you're not here today for any child porn, you're here for solicitation.
Correct.
How many deputies showed up?
Oh, there was probably 6 or 7.
Did you have the opportunity to be interviewed by one of them?
Yes, I did.
Tell me what happened.
They asked me questions about the solicitation that I'm charged for, and I didn't deny it at that point.
Did you in fact give them a full confession?
More or less, yes, sir.
Were you arrested on the spot?
No, sir.
When were you arrested?
I wasn't. I turned myself into Okaloosa on that Sunday.
Okay. How did you find out that there was an arrest warrant for you?
Jackson County, the deputy called me and told me.
And how long was that after the search warrant was executed?
I think that was on Friday afternoon, maybe Saturday morning. He called me and to let me know that they had issued a arrest warrant.
Okay. And did you make arrangements to come to Okaloosa and turn yourself in?
Yes, sir. I talked to him and I drove over to Okaloosa on that Sunday afternoon and turned myself in at the jail.
When you say you talked to him, who was?
The deputy at Jackson County.
Okay. And that was on Friday, you turned yourself in on Sunday.
Correct.
Did you ask him whether it would be okay to turn yourself in?
Yes, and he said that he would get with the Okaloosa County and find out, and he got back with me and told me that they said that was be okay, turn myself in Sunday.
And in fact, you met a deputy in the parking lot at the jail, is that correct?
Yes, sir, I did, and approached him and told him what I was there for.
Okay. And then what happened?
He said, just hang tight. He got my information, ran it in the system, whatever they do, and then me and him walked into correction facility together.
Did anybody, any type of investigator, police, FBI, sheriff's department, once you were arrested and processed into the jail at Okaloosa, did anybody interview you?
No, sir.
So, the confirmation of the information that the Okaloosa County Sheriff's Department eventually got came solely from the Jackson County Sheriff's Department, from your confession?
Yes, sir. As far as I know, yes, sir.
Okay. Thank you, Mr. Holder.
Your Honor, if I may.
You may.
Mr. Holder, I just want to ask you about that interview with the Jackson County deputies. Isn't it true you at first denied some of the questions that they had, for instance, that you had a kick account? Didn't you first deny that?
I don't recall that, ma'am. I don't recall that.
And didn't you, in fact, admit that you have looked at bad pictures and that it wasn't a one-night thing?
No, ma'am. I don't remember admitting to that. No, ma'am.
And you stated that it went on for a couple of weeks?
I don't recall that, ma'am.
And you also admitted that you were drawn to images of young girls?
No.
Thank you, Mr. Holder.
Thank you.
Mr. Switek, anything else?
No, sir, Your Honor.
Does the defense rest?
Yes.
Except for closing. Ms. Balsar, do you have any?
Your Honor, the state has no witnesses. What we will be asking the court to do is to rely on the attachments to our sentencing memo when we get ready to do the argument, specifically the chats and the OCSO police report that the defense has already stipulated as factual basis for the plea.
And those been formally admitted into evidence, or are you wanting them to be admitted into evidence?
Your Honor, they were formally e-filed with the court as an attachment to our sentencing memorandum. They were also provided to the defense at that time, and courtesy copies were sent as well. So we're just asking those to be considered by the court as part of our argument. We believe they're actually part of the court record already because they were e-filed. And yes, we're asking to formally be admitted into evidence if the court wishes that step to be taken, yes.
Mr. Swanton?
Your Honor, I would object. Clearly, incident reports would be hearsay.
Your Honor, the defense agreed the factual basis for the report, the basis for the plea was the report and the evidence that contained therein, and that is also the chat. So we would basically ask the court to consider that because that is part of the plea. That was part of the plea that Mr. Holder agreed to. That is the evidence in the case.
It may be the evidence as far as a factual stipulation for the basis of plea entry, but it doesn't give me the opportunity to inquire, and we are left with Ms. Bossow's presentation of whatever the state says the facts are.
It is the factual basis for the plea, and the plea is front and center in our discussion. So the court will consider it as based upon the fact that it's the factual basis for the plea itself.
Thank you, Your Honor. Then we'll reserve argument until after Mr. Zweig's argument. Thank you.
Mr. Zweig.
Thank you, Your Honor. Your Honor, you've heard testimony from 5 witnesses plus Mr. Holder today, asking for him to be admitted into the Mercy House program where he can receive counseling and rehabilitation rather than sending him down the road to a prison where he's going to get some discipline and structure by getting up at 5 o'clock in the morning and going over to the chow hall, and then for the rest of the day play a game of spades in the card room, in the day room. We think it would be much more beneficial to Mr. Holder and society as a whole if we're concerned about future incidents, as Ms. Bossow is in her sentencing memorandum, that he re-enters society being a good participant in society rather than coming out of prison with some counseling and a thorough knowledge of how to play a game of spades. Believe that there is one of the mitigating factors in 921.0026 that would apply, and that is that he did give a confession, and that is grounds for the lowest permissible sentence. No, excuse me. It is grounds for departure from the lowest permissible guideline sentence of 21 months. What the defendant has got to prove and what the state cannot argue is that his confession was not only voluntary, but made prior to his arrest and not after the fact. He went into great detail about his online activities when he was interviewed. And based upon that confession, an arrest warrant was applied for, and it was received back, and Mr. Holder voluntarily turned himself in. The state did not have to go to the burden of anything else besides relying on Mr. Holder's confession and what the investigator was able to ascertain as he was posing as a father of a 10-year-old girl, with pictures of somebody that was not even his daughter, as far as we know, was fully clothed in the pictures, and we know that Mr. Holder took no action as far as any kind of follow-up to come see that, quote, father and, quote, 10-year-old victim. Mr. Holder stayed in Hurley, Mississippi. So we would ask the court to deviate from the guidelines, order Mr. Holder to go to the Mercy House program for the full extent, whatever that is. I think they said up to 14 months, and have that as a condition of probation. And we are asking for the full sentence to, in fact, be probation, acknowledging that it has to be sex offender probation.
Ms. Boston.
Your Honor, as the court is well aware, the defendant is charged with soliciting a parent or guardian to have sex with his 10-year-old daughter using an electronic device online. And the minimum based on those charges is 21 months in Department of Corrections up to a maximum of 60 months in Department of Corrections. As I stated in a sentencing memo, we believe that this is not a minimum guideline sentence, and the state is actually asking for an adjudication of guilt, 5 years in Department of Corrections, designation as a sexual offender as is required by 943.0435, along with the other items that we mentioned, such as forfeiture of devices, court costs, and then that should not be allowed around children. Partially, he also would have to have sexual offender treatment and DNA samples and comply with the statutory requirements. That's all part of being a sex offender. But, Your Honor, the primary purpose of the legal system is to hold him accountable and to punish him for his actions. Rehab is not the primary purpose here. The purpose here, Your Honor, is to hold him accountable and keep the children and community safe from Mr. Holder, who is now a sex offender. The defense has asked for a downward departure. As the court is aware, in order for the court to downward depart, it's a two-part test. First, is there a legal basis therefore? And second, if there is it appropriate to do so? The defense is arguing that a mitigator would exist because he cooperated with the state to resolve the current offense. But not really, Your Honor. It wasn't based solely on his confession. First of all, Investigator Evans, after the chats, had to figure out who Mr. Holder was. He issued a search warrant to Kik, followed it up by Google, and was able to track it then ultimately to Mr. Holder's home. When they came to his home and confronted him with it, in other words, when he's basically caught, that's when he admitted to what he had done. So the sole basis for the arrest was not his confession. He didn't voluntarily turn himself in before he was arrested, before it came up. He turned himself in after they interviewed him and told him there was a warrant for his arrest. Those are all important because in order to be for a downward departure, the cases even that are cited in Platt that Mr. Swiatek refers to, it says a downward departure is not justified merely because the defendant cooperated after his offense was discovered. And that's citing State v. SUBIDO at 925 Southern 2nd, 1052. Also, the fact that he confessed, lacked a prior record, and garnered his mother's support in another case was not sufficient for a downward departure. So the fact that he confessed to the officers alone is not the basis for a downward departure. It does not meet the mitigating standard. And also the detailed confession that he gave, he actually denied some of those statements here today. So the court can believe how truthful he was.
based on his statements today. But, Your Honor, we do not believe that that does meet, based on even the case law that Mr. Switek cited within his memo, that Mr. Holder's actions do not rise to the level for the court to even consider it. And that even one of the cases that Mr. Switek cites, specifically, Your Honor, it says that when he confessed as a mitigating factor, turning oneself in, a full confession and pleading guilty is sufficient to support or may support a basis for a downward departure. So turning yourself in voluntarily, confessing, and coming forward, that might be a basis therefore, but we don't believe that that's even in this case. So we don't believe that the legal factual basis is, or the legal basis is there for the court to do so. And even if the court does believe that that mitigator has been met as a legal basis, the state does not believe that it's appropriate to do so. Mr. Holder has expressed a clear interest in children by his chats. He took some distinct steps. They discussed meeting up. He asked for more pictures of her. What I'd like to ask the court to do is to follow me through some of these chats, because these chats show why the state believes that this is not a minimum guideline case. First of all, the defendant is in the Florida daughter's room. He's in a place where already people are hanging out in chat rooms. He admitted he was going to chat rooms in order to meet these types of people that are interested in children. He admitted that in his confession, that this wasn't a one-time thing. So this wasn't a one-time thing that he was there. He admits there that he has a 14-year-old daughter. If you go down this, I'm on the second page of the chats, Your Honor. He's got a 14-year-old daughter. He's asked, "Are you active?" by the father. He answers yes. Then they establish where they're from. So the state is not merely speculating if he is active. That's his own statement. And that's what we're going to refer to. They start talking about what the father had done with the daughter. They says they're close, and he says, "I've done everything. What about you?" Asking the defendant, he said, "Just played around a little." So he's admitting to playing around a little with his daughter.
I'm going to renew my objection to uncharged conduct to preserve the record.
You may proceed.
Your Honor, we go on to the next page. He's asking for any pictures of the daughter. And the court can see how impossibly young this little girl looks in those pictures. This is a 10-year-old little girl in the context of the conversation that Mr. Holder is now expressing an interest in. He's denying that he ever sent a picture of his daughter or any person purporting to be the daughter, but in the chats you can see Investigator Evans or the father, Charles, asks, "May I see yours?" on that same page with the little girl. And then the next picture you see is what Mr. Holder, is now purporting to be his daughter, because that's the response. He goes on to ask for more pictures. He asks, "You all come over this way any?" Basically talking about meeting. He's asked by Charles, the father, "Are you interested?" His response is, "I'm very interested." He's asking for other pictures. He gets another picture of the little girl again. And then he says, "Hey, none in a bathing suit?" In other words, asking for something more revealing. So then he's asked by Charles, "So what would you like to do?" His answer is, "Whatever you allow." Says, "That's why I'm asking," trying to establish what this Mr. Holder might be interested in. And his response is, "I'd really like you to make her gag on my cuckoo." He goes, "I'm good with that. Anything else?" "Yes, take and eat that little pussy till it's good and wet, then fuck her till I come deep inside of her." That was his intent. That's the interest he's expressing, and that is what is causing the state concern. And the chats go on to talk about meeting up. And he asks later on, "I hope you'll share more pictures of her soon." There's more pictures that are shared again with her in the clothing, and the court's already seen. And close to the end of the conversation,
He says, God, she is perfect. And this is the page where at the top of it, she's in a sweatshirt, Your Honor. It's kind of half cut off. The defendant says, God, she is perfect. So I want her to suck my cock. Okay, I'm good with that. When do you think? He says, Charles. And he says, sometime next week. So it's the state's position that he expressed some very distinct desires, some very much of his interest in children. And even though Mr. Swatek says he never did anything after that in furtherance thereof, well, Your Honor, if he had taken any more steps in furtherance of traveling over here, then he'd be charged with traveling to meet. He's charged with soliciting, because he did, in fact, solicit this parent for the sexual acts that they discussed. And that's what we're here for, to hold them accountable for that, Your Honor. We believe those chats do show that he was interested in an impossibly young child, and he had every intention of engaging in sexual acts with her, and that does make him a danger. We ask the court to hold him accountable for that. Mercy House may be the answer for some, Your Honor, but that's not the answer here. The answer is not rehabilitation. The answer is to hold him accountable and keep our children and the community safe. And if he's serious about the rehab, that's certainly something that he can seek afterwards on his own. But, Your Honor, right now, the state believes adjudication, incarceration for the full period of time, and designation of the sexual offenders is the appropriate action, and we ask the court to do so. Thank you.
Swiatek, any
Yes.
response?
As far as Ms. Bossow's representation to the court that Mr. Holder intended to engage in a sexual activity with a 10-year-old, and he was going to do that, again, that's speculative, uncharged conduct. And we're trying to get there, but the facts just don't add up. You know, he didn't do anything but talk in a chat room. He didn't do anything further than that. As far as the other activities that, according to the incident report, Mr. Holder admitted to at that time, it's a year and a half ago. Mr. Holder didn't deny that he may have told law enforcement those things. He said he didn't remember telling law enforcement those things. And without some type of recording or testimony from a law enforcement officer or a video cam or something like that, they're nothing but mere ink on a page. It still comes down to, what are we going to do with Mr. Holder in 21 months or 36 months or 5 years in prison? And the state, in their memo, is concerned with just that. A period of incarceration of this length will assure that Mr. Holder does not have the opportunity to victimize an actual child. It assures the safety of the community while he receives the statutorily mandated sex offender treatment in a closely controlled environment. And those are the state's words. Are we concerned about the opportunity to victimize? Are we really concerned about that? Is that what the state wants? Is that he not have the opportunity to victimize? Well, that opportunity is only going to last for a period of months. 60 at max. If we're more concerned about society, then he should enter a program and get help. That's my argument, Judge.
Mr. Holder, if you'll stand at the podium. So, Mr. Holder, you've been charged and agreed to the charge of using a computer to solicit a parent. Your attorney framed the issue properly. What did you do? And what you did was solicited a parent of a 10-year-old child, somebody you believe was a 10-year-old child. That's not at issue here. What is at issue is what to do about it. And the reason why the mere soliciting rather than taking further action is a full felony with a maximum of 5 years is because the state believes that the solicitation itself is dangerous. And I will say that the court is interesting that a lot of other people talked about rehabilitation and the good work of Mercy House. But I didn't hear that acknowledgement from you. As a matter of fact, I heard a lot of equivocation and even excuses and even denial, even of things in the face of pretty clear evidence otherwise. Therefore, the court is going to have an adjudication of guilt to the count, the single count of using the computer to solicit a parent, and sentence the defendant to 5 years in the Department of Corrections, forfeit any electronic devices, the $867 in court costs. You'll also meet the statutory criteria for the designation of a sexual offender pursuant to 943.0435, subsection 1, specifically sex offender treatment, providing DNA samples and complying with all statutory registration requirements. And you apparently are a professed Christian. I respect that. I am also. You'll have plenty of opportunity to do that in jail, in prison. I hope you take advantage of it and deal with it sincerely. Thank you very much. We're going to take up. Does the statutory requirements automatically have no contact with minors, right? Does the court need to make a specific ruling on that?
DOC will not allow him to.
Well, I know while he's in prison.
Your Honor, while he's in prison, obviously we'd like no contact with minors, and the DOC enforces that. Once the 5 years passes, of course, our jurisdiction ends. Correct. As far as that. But there are special conditions as a sex offender that will then follow him, and that does govern where he can be as far as minors congregation.
And that's referenced in the statute.
That's correct, Your Honor.
Correct. Okay. Very good. So there's not a need for any formal ruling either way on that. Correct?
That's correct, Your Honor.
Okay.
Does the court have a copy of the score sheet for signature? Do I need to provide it? It was attached, but I don't know.
I mean, I have.
It was in the sentencing packet, but
Yeah,
not
I have that. I have that. Okay. I didn't know if it was.
I usually attach that, Your Honor. If not, I do have a blank one if the court needs it. Okay, Madam Clerk will probably want it.
Well, there's no probation, so we would have to go to collections.
Just good, straight to collections. Court has filed the score sheet.
Thank you, Your Honor.
Anything else that we need to do?
Not from the state in this case, Your Honor. Thank you.
Mr. Swatek?
All right.
Your Honor, may I be excused?
You may. And we will take a short recess. I know, Mr. Medina, we still have another case, and it's already 4:30.
Do you have good news for me? You want to let him know?
We need to bring him back in. I just need to let him know that he has the right to appeal this sentence. I failed to do that. Mr. Holder, I failed to tell you that you have a right. You have a right to appeal this matter, the sentencing that I just did. It must be done within 30 days. If you have any question regarding that, I'm sure your attorney is well versed in that arena, but I was required to say that for you. Thank you. Mr. Medina, if you've resolved, we're just going to have a plea agreement. Let's go ahead and do it. But if
what we're going to do is, may I just advise the court?
Sure.
Ms. Bradshaw is approaching, Your Honors. Christina Nicole Bradshaw at 18 CF 1569, 18 CF 2196, 22 CF 246, and 23 CF 1870. The parties have reached a plea and sentence agreement. It's been signed by Ms. Bradshaw, myself, and Assistant State Attorney Sharpless. Ms. Bradshaw, under the agreement, is going to have a driver's license suspension, and because that's going to ensure cars here, she's asking, where I'm asking the court on her behalf, and the state does not object, for her to come back to the court 2 days from today, October 19th at 9 a.m., to formally enter the agreement and be sentenced at that time, if that's okay.
I'm okay.
And that moves the motion in limine. We had already agreed to advise the experts they didn't need to remain on the Zoom call. Your Honor.
Well, I didn't pull them back in. I just exited out, so you'll have to call your witnesses.
Yes, Your Honor, I did call.
Oh, you did already.
Thank
okay.
You.
Okay.
If that's okay with the court, she'll be back day after tomorrow at 9 a.m.
Come back on the 19th at 9 a.m. and we'll do it.
Yes, ma'am.
Okay.
Just remind me if I don't add it onto the sheet that I...
Well, I don't have a file. So
I'll take that.
I want to see she signed it.
Yeah. Okay. Yes. You're free to go. Yes, ma'am. Come back 9 a.m.